plenary objection to the counterclaim on the same date. In this judgment, I will deal with the separately. I'll first consider and determine the claimant's originating summons together with the defendant's notice, as the PO will be taken first. Notice of preliminary objection. Thereafter, the notice of the claimant's motion for interlocutory injunction. And when you hear me punctuating while reading, it's because I'm using the opportunity to correct minor mistakes. That's what I'm saying. Okay. So the originating summons of the claimants, in the originating summons, the claimant submitted these questions for determination by this court. I have reeled out the questions there. There are altogether 8 questions. And the reliefs sought by the claimants in the originating summons I have also reeled out, and there are 20 reliefs. They are all captured in the body of the judgment. The case of the claimants has been summarized, as well as that of the defendants as well has also been, as well as the case of the claimant as contained in the affidavit in support of the claimant's originating summons. And then the written submissions in support of the originating summons have also been summarized. There are issues numbering 8 issues which have been submitted for determination. They have summarized the details of that. All the other processes filed by the claimants, a further affidavit and reply on points of law, which was filed on 29 September 2025. There are documents marked Exhibit Casus 1 and Casus 2, which were attached to the further affidavit. I have also seen another affidavit filed by the claimants on 3rd March 2026. I've examined the content of all these processes and the exhibited documents filed by the claimants in support of the originating summons. Then I went ahead to summarize the defense of the defendant as captured in the counter affidavit filed in response to the originating summons. The counter affidavit of the defendant filed on 15th November 2024 has been summarized as the case of the defendants filed in defense to the originating summons. Then I've also gone ahead to summarize the written submission of counsel for the defendants. Documents attached to the counter affidavit and marked exhibits 1, 2, 3, 4, 5, 6, and 7. There are written submissions captured in issues numbers 1 to 8 as well. And then the other processes filed by the defendants are a further counter affidavit on 13th November 2025, some documents marked exhibits A, B, C, D, E, F, and G, which were attached to the further counter affidavit. I have gone through the content of these affidavits as well as examine the exhibited documents. I'll make necessary reference to them as we go along. Now, the defendants filed a notice of preliminary objection on 8th October 2024, wherein they challenged the competence of the suit and the jurisdiction of this court. to entertain the suit. At this point, I will have to consider and determine the NPO first before going ahead to determine the originating summons accordingly. In the notice of, if the need will arise, in the notice of preliminary objection, 2 reliefs were sought: another striking out the claimant's suit for want of jurisdiction, another dismissing the claimant's suit for being an abuse of court process. There were 3 grounds of objection raised in the PO, but during the hearing of the PO on 4th March 2026, learned counsel for the defendants, Femi Aborisade Esquire, withdrew the first ground of objection, which is on abuse of court process. That ground is accordingly struck out together with all the arguments made under it. The remaining 2 grounds of objection and their particulars are as follows. There is the ground of prematurity, which has also been summarized. The grounds are numbering from A to I, and then the second ground is the lack of jurisdiction, and the grounds number from A to C. I have summarized the facts of the notice of preliminary objection and the submissions made in support of the notice of preliminary objection, the submissions of the defendants. I have also summarized the claimant's response to the defendant's notice of preliminary objection. All of these are already captured and embodied in the body of the judgments. As we speak now, I'm already on page 20 of the judgment, and I'm still going on. And other processes filed in respect of the defendant's PO. There is an affidavit of facts in support of the PO filed on 13th November. And then on 15th November, the defendants filed a further affidavit and reply on points of law in support of the PO. The affidavits of facts were deposed by the 4th defendant. A document marked Exhibit Brief was attached to the affidavit of facts, while documents marked A, B, C, D, and E were attached to the further affidavit. On the other hand, the claimants filed a further counter affidavit with a written address to oppose the PO, and a further and better counter affidavit of facts. These processes were filed on 3rd March 2026. Documents marked Exhibits A, B, C, and D were exhibited to the further and better counter affidavit of facts. I have read and noted the content of those other processes and those of the documents exhibited. I will make reference to them where necessary in the course of this ruling on the PO. Now, the decision on the notice of preliminary objection of the defendant contained on page 21 of the judgment reads thus: the defendants filed 1 ground of objection to be considered, which is whether this suit is premature. On the ground of objection that the suit of the claimant is premature, it is the case of the defendants that the first defendant's Constitution 2021 prescribes domestic remedies to be exhausted for internal settlement of disputes, but the claimants did not exhaust the prescribed domestic or administrative remedies before instituting this action on 26 June 2024. It was for this reason it was contended that this suit is premature. On the other hand, the claimants said they wrote letters of complaint to the 1st, 2nd, and 3rd defendants before the election of 3rd July 2024. But the 1st defendant ignored them and never took any actions to correct the violations. The claimants also asserted that the New Pen Constitution 2021 and the PTD Bylaws 2021 do not mandate internal dispute resolution as a condition precedent before an aggrieved member can approach the court for redress. In addition, Rule 5, Sub 6 of New Pen Constitution 2021 even gave the claimants the right to initiate this action at their own expense without any recourse to internal arbitration as a condition precedent. This is in addition to the argument that the claimants have a constitutional right to approach this court to seek redress. The parties refer to various provisions of the Constitution of the first defendant and the bylaw of the PTD branch of the first defendant to support their positions. The Constitution of the first defendant is Exhibit 6 of the affidavit in support of the PO. The content of Rule 5 has been captured in full and placed in the next paragraph. And then the bylaw of the PTDF of the first defendant, which is Exhibit 4, in support of the PO. The provision for branch delegate conference election is contained in Rule 17 H1 and H, I, and J, which provides as follows. I have also reeled them out in the body of the ruling. The grievance handling procedure is contained in Rule 30 H, which provides that every member of the branch must first exhaust all internal grievances handling procedure before taking the union matter to any external individual body or court. Now, the complaint of the claimants in this case is about the conduct of the PTD branch election of 3rd July 2024. Their complaint is that the election was not conducted in accordance with the orders given in the judgment of 29th May 2024. The provisions of the Constitution of the first defendant and the bylaw of the PTD branch, the grievances of the claimants arose from the internal branch election of the union. Rule 35 of the first defendant's constitution provides that such grievances should be internalized as much as possible, and the complaint must first be brought to the branch or zonal executives or to NEC, with specific respect to grievances arising from branch election. Rule 17H of the PTD branch bylaw provides any aggrieved party in the election, provides that Rule 17 provides that any aggrieved party in the election shall have the right of appeal to the NEC of the first defendant not later than 21 days after the election. The NEC of the first defendant is given the responsibility to entertain and determine the appeal within 30 days of receipt of the appeal. Without a doubt, both the Constitution of the first defendant and the PTD bylaws have made provisions for internal grievance resolution process, particularly with regard to grievances arising from branch election. Rule 30H of the bylaw made it mandatory for every member. I'm using the course, so I don't find it that easily. Made it mandatory for every member of the branch to first exhaust all internal grievances handling procedure before taking the union matter to court. The defendants have alleged that the claimants did not exhaust the internal grievance mechanism before instituting this action. I've carefully gone through the processes filed by the claimants in opposing the PO. From all that the claimants said, they seem to say that they attempted to explore internal remedy, but the defendants failed to attend to their complaint. It was stated in the claimant's counter affidavit that they wrote letters to the first, second, and third defendants to reject the election guidelines released by the first defendant. The letters were attached to the counter affidavit as Exhibit PTD1. In the submissions of their counsel, it was submitted that the claimants have shown the steps they took to see if the case could be solved internally, but to no avail. The claimants wrote a letter to the first, second, and third defendants and made their positions known before the election of 3rd July 2024. But the first defendant ignored them and never took any actions to correct the violations. The letter addressed to the General Secretary of the first defendant and written by solicitor to the claimants is dated 31st May 2024. It was written before the election of 3rd July 2024. Therefore, the letter is not a complaint against the conduct of the election. Also, the letter is not a petition or appeal to the NEC of the first defendant. In my view, this letter does not meet the requirement of an appeal by an aggrieved member in an election under Rule 17H of the PTD branch bylaw. After the election was conducted, The grievances of the claimants about all the infractions and breaches became crystallized. It is at this point they ought to have initiated the process in Rule 17H of the PTD branch bylaw to submit a petition to the NEC within 21 days of the election. In my view, the claimants' grievances arising from the PTD branch election, which took place on 3rd July 2024, was not submitted to the internal grievances resolution procedure of the first defendant before this action was brought. Other averments of the claimants were mostly to find justification for their failure. The claimants gave various reasons for their failure to exhaust the internal grievances handling process contained in the constitution of the first defendant and the PTD bylaws before bringing this action. They contended that Rule 35(1) of the first defendant's constitution is discretionary and not mandatory. It only encourages members to explore internal remedies in settlement of disputes. They also said the PTD bylaw never made exploration of internal mechanisms a condition precedent to access the court. I have examined Rule 35 of the first defendant's constitution again. When Sub-Rule 1A provides that complaints about union members must first be brought to the unit, branch, or zonal executive or NEC, this is not only discretionary but mandatory. Let me add that the word union members used in the provision includes every member of the union, whether in official or non-official capacity. Therefore, the claimant's complaints in this action against the role of the caretaker and electoral committees and all other union members in the conduct of the election of 3rd July came within the complaints required to be brought to the unit, branch, or zonal executives or NEC in Rule 35 of the first defendant's constitution. Again, contrary to the belief of the claimants, Rule 30H of the bylaw made it mandatory for every member of the branch to first exhaust all the internal grievances handling procedure before taking the union matter to court. The claimants also contended that their right of access to court is a constitutional right as provided for in Section 6(6) of the Constitution of the Federal Republic of Nigeria, 1999, and can only be taken away by a clear provision of the Constitution. That seems to be the position. However, the issue here is not about denial of the claimant's right of access to court, but whether they have fulfilled the condition precedent to exercise that right of access to court. Where the constitution of a union or association provides for internal remedies for the purpose of resolving internal disputes, such provisions are not intended to restrict the exercise of the members' right to access to justice. Such provisions simply create a condition precedent that must be fulfilled before the rights can be exercised. Put in another way, internal dispute resolution mechanisms provided in the rules of trade union or association must be explored as a condition precedent to the filing of a suit before a court. The consequence of failure to do so is that the precondition for access to court has not been satisfied. See Akiyemi versus Oume-Chili, 1995. The claimants also relied on Rule 5(x)(1), that's 5(11) of the Constitution of the first defendant, and said it gives the claimants the right to file this action as it is an action founded on disobedience to court order. Rule 5(11) provides as follows. Any financial member shall have the right to initiate action on his own expense in connection with any breach of the Constitution. The above provision reiterated the right of members to file action in court in connection with any breach of the Constitution of the first defendant. There is, however, no part of the provision that removes the duty of members to exhaust the internal grievances resolution mechanism of the first defendant before exercising the right to initiate an action in court. In this case, there is a procedure in the bylaw of the PTD branch of the first defendant for appeal by any member aggrieved with an election. Compliance with that procedure is a condition precedent which vests this court with jurisdiction to hear their grievances against that election. The claimants did not attempt that procedure, and that renders this suit premature. incompetent, and accordingly not properly before this court for adjudication. See Ozoije versus Olu, 2022. Claimants also made allegations of bias against the second and third defendants who are members of the neck of the first defendant. The claimants said these defendants cannot be sitting in a matter having to do with them. The fact that the claimants have the fear of bias is not enough for them not only to comply with the provisions of the bylaws in submitting an appeal against the election to the NEC. The second and third defendants are not the only members of NEC. The fact that the claimants did not submit any appeal or complaint to the NEC makes their allegation of bias merely presumptuous. In view of the foregoing, it is clear that the claimants did not exhaust the procedure before bringing this suit. That is to say, the claimants did not raise or submit any grievance or complaints to the NEC of the first defendant relating to the elections conducted on 3rd July 2024 at any time before filing this suit. The claimant's suit is therefore premature, having been instituted without first satisfying the condition precedent. In a situation of this nature, the failure to exhaust internal procedure for settlement of dispute before filing a suit robs the court of jurisdiction to adjudicate on the suit. This ground of the defendant's NPO has merit and it is allowed. Consequently, this suit is liable to be struck out and it is accordingly struck out. Now, the decision on the merit of the claimant's case. In the event my conclusion on the NPO is wrong, perhaps in the event of an appeal against the decision, I've decided to consider and give a decision on the merits of the case of the claimants. This is to avoid a situation where the case will be remitted back to this court for retrial in the event of a reversal of my decision on the NPO on appeal. The background facts of this case are that members of the PTD branch of the first defendant, who were polarized into factions, conducted two separate branch elections on 31st October 2023. The PTD branch dispute and the issues surrounding the said elections eventually came before this court for adjudication in suit NICN ABJ 312-2023. I presided on that case. In the judgment I delivered in the matter on 29th May 2024, I made the following orders. You are familiar with that judgment. I have, however, recast the orders I made. There are 7 of them, and they should be taken as read. They are contained on page 26 of the judgment. The full judgment is Exhibit Casus 3 of the affidavit in support of the originating summons. After the judgment, the first defendant hearing, who was the first claimant in suit ABJ 312, constituted both the caretaker and the electoral committees as ordered in the judgment. The notices of the composition of the caretaker committee and the electoral committee are Exhibit Casus 4 and Casus 5. Both documents are dated 30th May 2024. Then on 31st May 2024, the Electoral Committee released an election guideline for the PTD branch delegate conference to hold in Lagos on 3rd July 2024. The election guidelines is Exhibit Casus 6. The PTD branch election held on the scheduled date being 3rd July 2024, where new executives of the PTD branch were elected. The names and positions of those elected as executive of the PT branch in that election are contained in Exhibit Casus 12. The cause of action of the claimants arose from that election. Their complaints touch on the steps taken towards that election since after the judgment of 29th May 2024. And in order to have their complaints addressed, they have raised 8 questions for determination in the originating summons. I agree with the learned counsel for the parties that the questions constitute the issues to be determined in this suit. However, upon a careful examination of the questions, it is observed that the question will be conveniently determined in this manner. Question 1 alone, question 2, 3, 4, and 5 together, question 6 alone, question 7 alone, and question 8 alone. So, question 1. The complaint of the claimants in question 1 of the originating summons is that the defendants violated Rule 6D of the PTG branch by law. and the judgment of this court delivered on 29 May 2024, when they fixed the fresh election as ordered by this court for 3rd July 2024 and proceeded to hold the election on the same date. It was averred in the affidavit in support of the originating summons that by virtue of Rule 6D of the PTD branch bylaw, notice of election must not be less than 3 months, and the notice of election given after the judgment must be for clear 3 months. It was also stated that by virtue of the judgment, the election must be conducted in a period not less than 4 months from the day of judgment, and the fresh election must be held a month after the 3 months notice to meet up with the 4 months requirements. According to the claimants, 3rd July 2024 fixed for the fresh election is less than 3 months as required by Rule 6D of the PTD branch bylaw. For this reason, it is the case of the claimants that the deviation from the mandatory 3 months notice required by Rule 6D of the PTD branch bylaw makes the election null and void. In response to the contention of the claimants, it was averred in the counter affidavit of the defendants that the conduct of the election on 3/7/2024 was in strict compliance with the judgment of 29/5/2024. Rule 6 of the PTD bylaw provides for fixing of the dates and electoral rules within a period not later than 3 months. It is not true that the bylaw of the PTD branch of the first defendant provides that notice of election must not be less than 3 months, and that the judgment of 29/5 directed the first defendant to conduct the election within 4 months from the date of the judgment, and the conduct of the election was within 4 months period from the date of judgment. Learned counsel for the defendant submitted that the election held on 3rd July 2024 is not a violation of Rule 6D of the PTD bylaw or the judgment of this court. It was explained that Rule 6D did not provide for mandatory 3 months notice. Rather, the import of the rules is that the date of the election and the electoral rules had to be fixed within 3 months of the order of the court, but not outside 3 months. I have carefully considered all the averments and contentions of the parties relating to the issue in question 1 of the originating summons. The claimants complained that Rule 6D of the PTD branch bylaw prescribed a mandatory 3 months period for giving of election dates and release of electoral rules before the conduct of an election. What the claimants are saying in effect is that by Rule 6D, there must be a period of 3 months from the date notice of election is given and the date the election is conducted. The claimants exhibited the 2019 PTD bylaws to their further affidavit. It is Exhibit Casus 1, while the defendant exhibited the 2022 PTD bylaws to their counter affidavit as Exhibit 1. I have examined the provisions of Rule 6D of both the 2019 and 2022 bylaw, and I find that they have substantially the same provision. Rule 6D provides that the dates and the electoral rules shall be fixed not later than 3 months preceding the branch delegates conference date. This provision is not ambiguous. It simply means that the date on which the date of the election and electoral rules are fixed shall not be more than 3 months to the date the election is conducted. Put in another way, election is to be held not later than 3 months from the date of the election. Sorry, I repeated a word there. From the date of the election, and the electoral rules were fixed. I totally agree with the interpretation given to the words "not later than" by learned counsel for defendants in paragraphs 3.1.6 and 3.1.8 to 3.1.9 of the written address in support of the counter affidavit. In the context of Rule 6D of the PTD bylaw, not later than 3 months means within 3 months or not beyond 3 months. Thus, the view of the provision of Rule 6D of PTD bylaw, the fixing of the date of election and the electoral rules had to be done within 3 months to the actual date of the election. Contrary to the belief of the claimants, Rule 6D did not provide for a mandatory 3-month period for giving of election dates and release of electoral rules before the conduct of it. The notice of election dates and electoral guidelines was given on 31st May 2024 via the Exhibit Casus 6. Election was held on 3rd July 2024. The election date and electoral rules were fixed within 3 months to the date election was conducted. I find that the defendants complied with Rule 6D of the PTD bylaw. With regard to the allegation that the judgment of 29th May was also violated when the defendants fixed the election for 3rd July 2024, I have considered the fourth order made in the judgment. The first defendant was directed to constitute an electoral committee who shall conduct the election within 4 months from the date of the judgment. This order is also not ambiguous. For the sake of clarity, it means that the PTD branch election must be conducted within 4 months from the date of the judgment. The judgment was delivered on 29th May 2024, and the election was conducted on 3rd July 2024. The election was conducted within 4 months as directed in the judgment of this court. I find in the result that the PTD branch election conducted on 3rd July 2024 was not conducted in violation of Rule 6D of the PTD bylaw or the fourth order contained in the judgment of this court delivered on 29th May 2024. The result is that I resolve question 1 in the negative and against the claimants. Questions 2, 3, 4, and 5. In questions 2 and 3 of the originating summons, the claimants want this court to determine whether the failure to give the claimants automatic qualification to contest the 3rd July election and the failure of the first to third defendants to include the claimants or their supporters in the caretaker and electoral committees is not contrary to the order of inclusiveness and non-discrimination made in the judgment of 29th May 2024. Then in questions 4 and 5, the claimants want this court to determine whether the appointment of the fourth defendant and his allies as chairmen and members of electoral committees and appointment of the sixth defendant and his allies as chairmen and members of caretaker committee by the first to third defendant without any appointment from the faction of the claimants is a violation of the all-inclusive aspect of the judgment of this court. Clearly, questions 2, 3, 4, and 5 of the originating summons are founded on the same complaint that the defendants violated the order of inclusiveness and non-discrimination made in the judgment of 29th May 2024. Thus, the questions are connected and will be determined together. From the averments in the affidavit in support of the originating summons and the arguments made by the learned counsel for the claimants on the issues, the case of the claimants arising from questions 2, 3, 4, and 5 is that the order of inclusiveness and non-discrimination made in the judgment of 29th May envisages and contemplates that 1. The claimants who have earlier participated in the annulled elections of 31st October 2023 are automatically qualified to contest the fresh election ordered by the court upon purchase of forms. 2. The members or supporters of the claimants shall be included in the composition of the caretaker and electoral committees along with members of the other faction. Let me repeat some of the orders I made in the judgment of 29th May 2024, which are relevant to the determinations of questions 2 and 3 of the originating summons. 2. An order is made directing the first claimant to conduct a fresh election into the national offices of the PTD branch of the first claimant. 3. The first claimant is ordered to conduct this fresh election in strict compliance with and within the electoral rules and procedure provided in the first claimant's constitution and the PTD bylaws. The first claimant is also ordered to make the election all-inclusive and non-discriminatory on any account. The first claimant is ordered to forthwith put the process for the new election in motion by constituting an electoral committee as ordered in the judgment in suit number NICN YEN1 2022, who shall conduct the election within 4 months from the date of this judgment. 5. pending when the new executives of the PTD branch shall emerge from the election to be conducted, the first claimant shall, within 7 days from today, constitute a caretaker committee to run the affairs of the PTD branch. No member of the caretaker committee shall be a member of the electoral committee. All these orders were directed to the first defendant. In Order 3 of the judgment, the first defendant was given the authority to conduct the fresh election, provided it was conducted in strict compliance with the electoral rules and procedure contained in its constitution and the PTD bylaw. Now, the order of inclusiveness and non-discrimination specifically related to the election, that is, no member should be prevented or discriminated against from contesting in that election. There's no part of the judgment where the court pronounced that the claimants or anybody who had earlier participated in the annulled election are automatically qualified to contest the fresh election upon purchase of forms. Let me add that the order of inclusiveness and non-discrimination cannot also be stretched, as the claimants have tried to do, to mean that automatic qualification to contest in the fresh election has been given to those who contested in October 2023 election. The order for inclusiveness and non-discrimination is no more than allowing the claimants to participate in the election. I have seen evidence in this matter showing that some of the claimants obtained nomination forms, submitted the forms, and they were cleared to contest the election, but they decided not to participate in the election. The claimants contended that the non-inclusion of members or supporters of the claimants in the electoral and caretaker committees violated the order of inclusiveness and non-discrimination made in the judgment of 29 May, and therefore renders the caretaker and electoral committees invalid. In Orders 4 and 5 of the judgment, the first defendant is to constitute an electoral committee and a caretaker committee. The only condition attached to Order 5 is that no member of the caretaker committee shall be a member of the electoral committee. Other than that, the first defendant was given the discretion to decide on the composition of the committees. There is nowhere in the judgment where the court specified those that the first defendant will appoint into either of the committees. The court never said the first defendant must, in composing the committees, include members of factions or the claimants and their members. The court did not also disqualify any person or member of the first defendant, whether having served in a previous caretaker to electoral committee or not, from being appointed into the caretaker or electoral committee as ordered by the court. In the absence of any specific directives into the first defendant as to the kind of members to appoint into the committees, the court cannot fault the composition of the committees simply because the claimants feel that their supporters or members of their faction were not included as members of the committees. From the whole gamut of the grievances expressed by the claimants under questions 2 to 5 of the originating summons, it is observed that the claimants are merely seeking to input their perceptions and assumptions into the judgment of 29 May 2024. The claimants cannot add their perception into the judgment or attempt to read a meaning to the judgment to suit their purpose. Contrary to the position of the claimant, the order of inclusiveness and non-discrimination made in the judgment of 29 May 2024 does not contemplate or cover those matters which the claimants attempt to read into it. For these reasons, questions 2, 3, 4, and 5 are also resolved in the negative and against the claimants. Question 6. Question 6 of the originating summons is to determine whether, when the election of 31st October was annulled in the judgment of 29 May, all the actions taken by those elected in those elections, including appointments and removals made by those whose elections were nullified, are also null and void. In the affidavit in support of the originating summons, it was averred that when the judgment of 29 May 2024 nullified the election of Comrade Egbon Augustine and his allies, all the appointments, removals, and other actions done by the said Comrade Egbon Augustine in conjunction with the third defendant becomes null and void. It was also averred that by the judgment of 29 May 2024, all persons, officers, or officials that were removed have been restored to their various offices. The contention of claimants was further clarified in the written address in support of the originating summons. Counsel for the claimants explained that the election held in Ibadan, 31st October 2023, produced Egbon Augustine-led executive, After the election, the first to third defendants suspended or removed the officers or officials who were supporters of the claimants and replaced them with their favored persons. It was submitted that when the judgment of 29th May 2024 nullified the Ibadan election of 31st October 2023, it affected the Egbon Augustine-led executive together with all appointments made by it and those made by the first to third defendants, such that all persons, officers, officials who were removed or suspended by the Egbon Augustine-led executive and the first to third defendants pursuant to the annulled election are restored to office, while all actions and appointments made by Egbon Augustine-led executives and to the first to third defendants cease to subsist. In the response of Learned Counsel for the defendants, it was submitted that where an election is nullified for any reason, the nullification usually does not affect official acts of the officers or persons whose election had been nullified. Counsel submitted still that any removal or suspension of officers carried out by the first to third defendants and the Egbon-led executive were official acts which were not nullified by the nullification of the election. Counsel added that the order restraining the Egbon-led executive elected in the nullified election of 31st October 2023 took effect from the date of judgment and not retroactively. In the judgment of 29th May 2024, both elections held differently by members of the PTD branch of the first defendant on 31st October 2023 at the International Conference Center, Ibadan, and Top Rank Galaxy Hotel, Abuja, were nullified. And in order one of the judgments, those elected in both elections were restrained forthwith from parading themselves as national officers of PTD branch of the first defendant. From the pronouncements made in the judgment, only the elections were nullified and not the acts done by those elected before the nullification of the elections. It is clear from order one of the judgment that the elected officers in the 31st October 2023 elections were restrained from functioning in their elected offices from the date of the judgment. Thus, the acts done by those elected officers prior to the nullification of the elections were official acts at the time and therefore valid. It is only upon nullification of their elections that any act carried out by them thereafter will be null and void. Question 6 is resolved in the negative and against the claimants. Question 7. It was averred in the affidavit in support of the originating summons that upon the nullification of the Ibadan election, the defendants removed all the PTD zonal chairman, secretaries, treasurers, trustees, and delegates from PTD units, and all members of the National Executive Council of the Union who are from PTD branch that were neutral and replaced them with their cohorts and agents. It was stated that the present officers occupying all the PTD branch positions are all supporters and agents of the defendants. And by the guideline released by the defendants, the claimants faction will not have a single delegate to the delegate conference for the purpose of the fresh election. Counsel for the claimants submitted that any delegate list made from the units, zones, state, or national based or on actions and appointments made after the annulled election are of no value. It is on this basis the claimants question 7 of the originating summons sought to be determined whether such delegate list can be used for the purpose of the fresh election. The defendants averred in their counter affidavit that by a notice dated 14/6/2024, the Electoral Committee published the delegates list for 3/7/2024 Special Delegates Conference election and called for complaints from members against the list, but the claimants did not lodge any complaints or objections against the list till date. In his submissions, Learned Counsel for the defendants submitted that the claimants can no longer complain about the delegates list as they were given an opportunity to lodge complaints, but they failed to seize the opportunity. Rule 7 of the PTD bylaw mentioned the following persons, officers who comprise the branch delegates for the branch delegates conference. 1, the branch national officers. 2, zonal chairmen. 3, secretaries, treasurers, and trustees. 3, delegates from units are chairmen, secretaries, treasurers, and trustees. And 4, all members of the branch working committee who are members of NUPENG-NEC. The claimant's complaint in this issue is not that those contained in the delegate list used for the 3rd July election were not the officers mentioned in Rule 7B of the bylaw. The claimant's complaint is that the defendants removed all the PTD zonal chairmen, secretaries, treasurers, trustees, and delegates from PTD units, and all members of the National Executive Unions, Executive Council of the Union who are from the PTD branch and were neutral. The defendants then replaced the removed officers with the defendants' agents and supporters, so that the claimants' faction did not have a single delegate in the delegates for the first fresh election. From what has been said in the affidavit of the claimants, it is obvious that those who constituted the delegates for the fresh election were members of the PTD branch in their capacities as zonal chairmen, secretaries, treasurers, trustees, and delegates from PTD units, and all members of the NEC. Oh, what did I do? Because the claimants were unable to convince me that the persons comprised in the delegate list for the said election were solely agents and supporters of the defendants. If the persons who made up the delegate list were the officers mentioned in Rule 7B, please answer, tell him that he can come. I'm reading judgment. You can just, it's WhatsApp call. I'm at home. Look, you can go in there and answer it. I'm so sorry for that distraction. The claimants were unable to convince me that the persons comprised in the delegate list for the said election were solely agents and supporters of the defendants.
Maybe the problem is that's true. My Lord, sir, we are not hearing any sound. No sound at all. No sound at all, sir.
Can you hear me now?
You can hear the court now, sir.
At what point did you stop hearing me? Or I should just continue, since you are going to get a copy of the judgment. Okay.
Yes, sir.
In his submissions, learned counsel for the claimants argued that the defendants have disclosed bias against the claimants not to allow the claimants participate in the fresh election ordered by this court. As such, the present leadership of the first defendant cannot be entrusted with the conduct of the fresh election ordered by this court. And that is why the claimants have invited this court to order that the fresh election is to be conducted by the past presidents of the first defendant and all former chairmen of the PTD branch of the first defendant. In response, it was stated that in the defendant's counter affidavit that the only authority saddled with the responsibility of conducting elections for all its branches by virtue of the rules and regulations governing the first defendant is the first defendant. Learned counsel for the defendant submitted that this court had entrusted the first defendant with the conduct of the fresh election, and as such, the election cannot be conducted in a manner desired by the claimant. It was also submitted that there is nowhere in the Constitution of NUPENG 2021 and the PTD bylaws 2022 that the past presidents of the first defendant and all former chairmen of the PTD branch of the first defendant can conduct a fresh election. I have observed that question A of the originating summons is not a question of interpretation of any part of the judgment of 29th May 2024, nor does it call for interpretation of any provision of the Constitution of the first defendants or the PTD bylaw. Thus, the claimant's invitation to this court to order all past presidents of the first defendant and all former chairmen of the PTD branch of the first defendant to conduct the fresh election is not founded on the interpretation of any provision of the Constitution of the first defendants or the PTD bylaw. Let me add that the Constitution of the first defendants and the PTD bylaw have made provisions on how and who conducts elections in the national body and in the branches and units of the first defendant. I have not seen where any role is given to past presidents of the first defendant and all former chairmen in the conduct of PTD branch election. This court cannot therefore rewrite the Constitution of the first defendants and the PTD bylaw by acceding to the request of the claimants. In the judgment of 29 May 2024, this court gave the responsibility to conduct the fresh election to the first defendant, and the election was to be conducted within 4 months of the judgment. I have seen evidence in this suit showing that the election has since been conducted on 3rd July 2024. Which other election is the claimants asking the court to invite the past president and all other former chairmen to conduct? Definitely not the election which was ordered by this court in the judgment of 29 May 2024. That election has been conducted. Any other election after the one ordered in the judgment is not within the ambit of this judgment. The court cannot therefore be dictating to the first defendant how and who conducts its elections. The reason the claimants want past president and all former chairmen of the PTD branch invited to conduct the fresh election is that the defendants have shown bias towards the claimants and as a result, the present leadership of the first defendant cannot be entrusted with the conduct of a fair election. Even if the allegation of bias raised by the claimant is true, there's a limit to which this court can interfere in the internal matters of the first defendant. The court cannot take over the running of the first defendant, neither can the court turn itself into the supreme organ of the first defendant who dictates how elections in the first defendant is conducted. The disputes between members are an internal matter. The court, as an umpire, can only entertain and determine complaints founded on breaches or infractions of the Constitution or bylaw of the first defendant. Thus, the allegation of bias raised by the claimant cannot induce this court to compel the first defendant to act outside the electoral rules in its Constitution and the PTD branch bylaw. Accordingly, Question 8 is resolved in the negative and against the claimants. In concluding my decision on the merits of the claimant's originating summons, it is clear that all the questions in the originating summons have been resolved against the claimants. The implication is that there is no merit in the originating summons. The suit of the claimants and all the relief sought by them are dismissed. Now to the claimant and the defendant's counterclaim. The defendant submitted for determination in the counterclaim are as follows. They are numbered from 1 to 9, and they sought reliefs in that counterclaim, also numbering from 1 to 11. The counterclaim was supported with an affidavit and a written address. The defendants also filed a counter affidavit and a reply on points of law in support of the counterclaim on 13th November 2025. In defense of the counterclaim, the claimants filed a counter affidavit and written address on 11th November 2024. On the same 11th December 2024, the claimants filed a notice of preliminary objection to the defendant's counterclaim. I have examined these processes, and my view is to determine the NPO first. Now, I have summarized the notice of preliminary objection of the claimant, which has 10 grounds. The 10 grounds are listed here. The notice of preliminary objection was supported with an affidavit titled Affidavit in Opposition of the Counterclaim to Correspondence Counterclaim, Counterclaimants through Correspondence Counterclaim, and a written address also titled Written Address in Opposition of the Counterclaim Claimants through Correspondence Counterclaim. The facts in support of the PO are contained in paragraph 4 of that affidavit. I have carefully examined the facts deposed in paragraph 4A to find the depositions therein to contain legal arguments, conclusions, objections, and prayers in violation of the provision of section 1152 of the Evidence Act. Affidavits are to contain only statements of facts, and any extraneous matter or conclusions which are fit only to be urged upon in legal arguments or submissions cannot be contained in an affidavit. The depositions in paragraphs 4A to H of the affidavit filed in support of the PO offend section 1152 of the Evidence Act, and they are accordingly struck out. I have summarized the written address in support of the PO, where 3 issues were raised for the determination of the court, issues 1, 2, and 3. And in response to the 3 issues raised, the claimants raised issues raised in the claimant's written address in support of the PO. The defendants also argued issues 1, 2, and 3. And then here is the ruling of the claimant's PO. I have compared the questions this court had determined in the claimant's originating summons and the questions the defendant have submitted for determination. I find that questions 2, 3, 4, 5, 6, 7, 8, and 9 of the counterclaim are the same to all intent, effect, and purpose with questions 1, 2, 3, 4, 5, 6, 7, and 8 of the originating summons. The defendants merely reframed the question. Let me add that the deponent of the affidavit in support of the counterclaim had stated in paragraph 4 of the affidavit that he adopts his depositions in the counter affidavit in opposition to the claimant's originating summons and relies on same as part of the affidavit in support of the counterclaim. The implication of this averment is that the same set of facts already considered in determining the originating summons are the same facts to be considered in determining the counterclaim. I agree with the claimants that the question in the counterclaim are duplications or rehashing of the same questions in the originating summons. However, this does not make the counterclaim an abuse of court process. The counterclaim, although a separate action, is connected to the action. The fact that the question, reliefs, and facts of the counterclaim are the same with those of the main action does not make the counterclaim an abuse. The counterclaim may simply become academic when the issues in it have been determined in the main action. I hold, therefore, that the counterclaim is not an abuse of court process. It is clear to me that the issues arising for determination in the counterclaim, except question 1, have been exhaustively considered and determined in the judgment of this court or the claimant's originating summons. My decisions on questions 1, 2, 3, 4, 5, 6, 7, and 8 of the originating summons have been answered. Questions 2, 3, 4, 5, 6, 7, 8, and 9 of the counterclaim have answered questions 2, 3, 4, 5, 6, 7, and 8 of the counterclaim. Consequently, these questions of the counterclaim have become academic. So also have reliefs 3, 4, 5, 6, 7, 8, 9, 10, and 11 of the counterclaim been resolved when all the questions in originating summons were resolved against the claimants. The third ground of the NPO is that the allegation of the claimants parading themselves as executive members of the union cannot be determined by originating summons. That complaint of the defendants in their counterclaim is founded on question 1 of the counterclaim, where the defendants asked this court to determine whether the claimants and their cohorts can still validly parade themselves as national officers of the PTD branch in view of the first order in the judgment delivered on 29 May 2024 in ABJ 312. This question is a question of construction of the judgment of this court in suit ABJ 312. In my view, the question can be determined by originating summons procedure. In the result, the NPO fails and it is dismissed. The only question to be determined in the counterclaim is question 1. All other questions haven't been determined in the originating summons. I then briefly summarize what was left of the counterclaim and the written address of on that question 1, as well as the defense of the claimants to the counterclaim. In doing that, it is observed that the depositions in paragraph 4 of the counter affidavit are the same with paragraph 4 of the affidavit in support of the claimant's PO. Paragraph 4 of the counter affidavit to the counterclaim suffers from the same defect which resulted to the striking out of paragraph 4 of the claimant's PO. The depositions in paragraph 4 of the counter affidavit to the counterclaim contain legal arguments, conclusions, objections, and prayers in violation of provision of section 112 of the evidence 1152 of the Evidence Act. The depositions in paragraphs 4A to H are struck out. Of the claimant's counter affidavit to the counterclaim are struck out. It is also observed that the same issues and arguments made in the written address in support of claimant's PO, which issues have been determined in the PO, are the same arguments and issues contained in the written address in support of the claimant's counter affidavit. I will therefore disregard the arguments made in the written address in support of the claimant's counter affidavit. Decision on the merits of the counterclaim. The first question in the counterclaim is to determine whether the claimants and their cohorts can still validly parade themselves as national officers of the PTD branch of the first defendant in view of the first order in the judgment delivered on 29 May 2024 in ABJ 312. The said first order of the judgment, this court directed as follows. The defendants who claim to have been elected in the election held at Top Rank Galaxy Hotel, Utako, Abuja on 31st October 2023, and the persons who the claimants claimed to have been elected in the election conducted on 31st of October 2023 at the International Conference Center, Ibadan, are restrained forthwith from parading themselves as the national officers of the PTD branch of the first claimant. This order was made on 29th May 2024. From that day, all the persons who were elected in both PTD branch election held the two elections held on 31st October 2023 ceased to hold office and cannot act in the offices or parade themselves as officers of PTD branch of the first defendant union. In the affidavit in support of the counterclaim, the defendants averred that the claimants have been parading themselves as the national leaders of the PTD branch of the first defendant and gave details of the instances, places, and dates where the claimants have done so. The claimants did not challenge or deny these facts adduced by the defendants. The implication is that the claimants admit that they have been parading themselves as national officers of the PTD branch of the first defendant after the judgment of 29th May 2024. It is therefore undisputed that the claimants failed to comply with the order of this court, which restrained all members of the first defendant who got elected on 31st October as national officers of PTD branch of the first defendant from parading themselves as such. Question 1 of the counterclaim is resolved in favor of the defendants. Having resolved the sole existing question in the counterclaim, release 1 and 2 of the counterclaim are granted. It is accordingly declared that the claimants or anybody who lay claim to any national office of the PTD branch of the first defendant from the election of 31st October 2024 cannot parade themselves as national officers of the PTD branch of the first defendant in view of the first order in the judgment delivered on 29th May 2024 in suit ABJ 312. The court hereby reiterates its order in the judgment delivered on 29th May 2024 in suit ABJ 312-2023 to the effect that all persons parading themselves as national officers of PTD branch of the first defendant by virtue of the election of 31st October 2024 are further restrained from parading themselves as national officers of the PTD branch of the first defendant. Now the ruling on the claimant's motion for interlocutory injunction. On 30th January 2024, the claimant filed a motion wherein they sought the following orders. The orders are listed as numbers 1 to 6, which I have captured in the body of the judgment. Parties joined issues on the motion and it was held on the same day the originating summons filed by the claimants and the counterclaim filed by the defendants were held. Ruling on the motion was reserved to be delivered together with the judgment in the suit. The prayer sought in the motion disclosed that there are orders to be made pending the hearing and determination of the substantive suit. Now that the suit has been heard and determined, the motion no longer has any value or need for consideration, particularly the claimants who brought the motion did not succeed in the originating summons. The effect of the failure of the claimant's suit is that the foundation upon which the motion was anchored has collapsed. Consequently, the motion is liable to be struck out, and it is hereby struck out. Parties shall bear their respective costs. Above it is the decision of the court, and it is entered accordingly.
My Lord, we are most grateful to the court for the industry put into delivering this objective, comprehensive, well-considered, and well-reasoned judgment delivered for a period of about 2 hours or perhaps more. We are most grateful to the court. Much obliged, sir.
If I was to read the entire judgment, it would have taken the whole day. That's why I had to abridge the reading.
Yes,
but the judgments are immediately available for collection in the next, let's say by 12 o'clock, you can approach the registry of this court to get copies of the judgment.
As the court pleases. We are most grateful, sir.
Thank you.
All right, my lord. My lord, we are most grateful for the judgment.
Thank you. So I'll exit the meeting room now.
As the court pleases. Yes. Ekwele. 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 Oh, I didn't look at the face. That's right. That's right. That's right.